So, March 14th, defendant motioned to dismiss the indictment. First, the defense argues that the previous prosecutors and indictment were defective. They spent several pages of their motion talking about that, writing about that. But it doesn't matter that the previous prosecutors in the indictment were defective because they're gone. They were dismissed. So this is an irrelevant argument that, of course, Kerry Morrissey need not address. The defense argues that the new prosecutors, meaning Kerry Morrissey, sought to limit the defense time to file an alert letter with the grand jury. So an alert letter, folks, is a letter written by the defense that the prosecution is obliged to provide to the grand jury. And basically, it's alerting the grand jury to witnesses and evidence that the defense believes are exculpatory to their client, that are consistent with their client's innocence. And so under New Mexico law, the defense has the privilege to present this alert letter, or to have the prosecution present the alert letter to the grand jury. Keep in mind, the grand jury is not really an adversarial process like a trial. The defense doesn't really get to present a defense to the grand jury. It's the prosecutor's theater. So the prosecutor is the one speaking to the grand jury, not the defense. There are no defense lawyers speaking to the grand jury. Very one-sided in that respect. That's by design. That's how grand juries always are. But in New Mexico, the defense at least has the opportunity to file this alert letter that has to be shared with the grand jury. In fact, Kerry Morrissey, the prosecutor, literally read it aloud to the grand jury, as well as providing them with printed copies, alerting the grand jury to evidence the defense wants the grand jury to be aware of. And at one point, the prosecutor was moving forward with a grand jury that had been scheduled, and they wanted to move forward quickly. And they asked the judge to limit the time the defense had for drafting their alert letter. Whether or not you think that's inappropriate, it doesn't matter, because the defense complained to the judge, and the judge said, yeah, I'm not going to limit the time. So the judge ruled in favor of the defense. The defense got more time. That scheduled grand jury did not hear argument from the state. The state had to make its argument to a later scheduled grand jury, a different grand jury. So the defense ultimately had all the time it needed for its alert letter, so no harm done here either. Here's the big one. The defense says that the prosecution failed to share exculpatory evidence with the grand jury. So although it's not a adversarial process in which both sides, the state and the defense, have an equal opportunity to present evidence to the grand jury, if there's genuinely exculpatory evidence, the prosecutor is obliged to present that to the grand jury. Now, it's important to understand what genuinely exculpatory evidence means. It means it goes to a material element of the criminal charge or a material element of some legal defense that's being raised. That's what makes evidence relevant. Does it help the jury decide to a greater or lesser degree that a fact has been proven, a material fact, material to the charge or defense, has been proven or not proven? Evidence that doesn't do that is not relevant and is not in any material way exculpatory. So to give an extreme example, say, for example, the defense wanted to present to the grand jury evidence that Alec Baldwin, when he was a child, used to shovel his neighbors' driveways for free. Is that a nice thing to say about Alec Baldwin? Does that make him look like a caring and giving person? Sure. Is it material to the criminal charge of involuntary manslaughter in this case? No, it has nothing to do with the criminal charge. So although it's a feel-good story about Alec Baldwin, it's not material, it's not relevant, and therefore it's not exculpatory in the context of the criminal charge. So what kind of evidence did the defense want to present to the grand jury? Well, they wanted to present testimony from Joel Souza, the director of Rust, David Halls, the first assistant director who handed Alec Baldwin the gun with the bullet in it, Sarah Zachary, the props master for the set, Ryan Smith, a producer of the movie, financial producer of the movie, wanted testimony from all these people saying they didn't think it was Alec Baldwin's fault that he fired the gun that killed Helena Hutchins. Well, that's nice that they don't think it was Alec Baldwin's fault, but is that material? Do they get to make the legal determination? Does their legal opinion on a final, ultimate finding of fact matter? Or is that the province of the jury? All of their testimony is just, well, we think Alec Baldwin's a nice guy and shouldn't be held responsible. That's not exculpatory evidence, folks. It doesn't negate an element of the criminal charge. It doesn't go to an element of a defense. They want to point out things like the script supervisor who called 911 after the shooting described the shooting to 911 as an accident. Well, that's not a material fact. The script supervisor doesn't have any legal expertise or authority to determine whether or not the shooting was legally an accident. That's not material. They point out that OSHA, which investigated the shooting, didn't find Baldwin at fault. Well, OSHA doesn't find individuals at fault. They're not permitted to do that. OSHA's mandate is to find out whether a company has fault. And of course, they did find that. And they fined Rust with the highest fine possible under New Mexico law. The defense wanted to present a letter signed by many of the cast and crew contesting that Rust was inherently unsafe. Well, it really doesn't matter if Rust was inherently unsafe. All that matters is whether Alec Baldwin, in the moment he shot Helena Hutchins, was unsafe. So this is irrelevant testimony. They wanted to present testimony from the lead investigator, Alexandra Hancock, and Detective Cano, who would testify about things like, what were they going to testify about? Things like the investigation could have been better, for example. Mistakes were made in the investigation. And that's true. Like guns were picked up with bare hands as opposed to, like the gun that Alec Baldwin was handling, with a bare hand of a police officer as opposed to wearing a rubber glove. That's poor form in terms of evidence gathering, because of course the officer might put his own prints or disturb prints that were on the gun. But none of these errors in the investigation were material because for example, there's no dispute who was holding the gun when it was fired. So it doesn't matter what other fingerprints are on the gun. We know the gun was in Alec Baldwin's hand when it discharged and killed Helena Hutchins. Then the defense wanted to present testimony from a Robert Schilling, who was a contract investigator hired by the state, whose contract was not renewed and then was embittered and began to criticize the investigation in much the way I just described, saying it was one of the worst investigations he's ever seen, sloppy, etc. But none of the sloppiness goes to any material contested fact in the case. So again, irrelevant, not material, meaningless. What does matter in this case? Let's take a look at that. Alec Baldwin is charged with manslaughter, specifically involuntary manslaughter. So we can take a look at the actual New Mexico statute for this. 30-2-3. Involuntary manslaughter, paragraph B. Involuntary manslaughter consists of manslaughter committed in the commission of an unlawful act, not amounting to a felony. And the state is arguing here, this is one path to conviction, that Alec Baldwin this is a second crime with which he's charged. Negligent handling of a firearm is a crime under New Mexico law. So if the jury concludes that it's been proven beyond a reasonable doubt that Alec Baldwin was committing negligent handling of a firearm, that's a crime. That's an unlawful act, not amounting to a felony. It's a misdemeanor. If it did amount to a felony, Alec Baldwin would be looking at felony murder, right? But he's not. Negligent handling of a firearm is an unlawful act, not amounting to a felony. It's only a misdemeanor. And in the course of committing that negligent handling of the firearm, the death of Helena Hutchins resulted as a consequence. That's one path to Alec Baldwin being found guilty of involuntary manslaughter. The other path is that if you don't believe he was engaged in an unlawful act, if you believe he was engaged in a lawful act, which could produce death in an unlawful manner, meaning this was not a justified shooting of Helena Hutchins. Obviously, it was not, for example, self-defense. In the unlawful manner or without due caution and circumspection, and the death of Helena Hutchins resulted from that conduct, that's also involuntary manslaughter. What's without due caution and circumspection? Well, it means that if you're in the context of handling an inherently dangerous instrument like a gun, that you have a absolute obligation to make sure that you don't kill somebody with that gun through your own intentional conduct. Now, this is not a case where Alec Baldwin was struck by a piece of the set falling on him and he drops the gun and the gun discharged when it hits the ground. That might be an accident. Accident is also a legal defense that could be raised to this charge of involuntary manslaughter, but no one's alleging that's what's happened. Really, the uncontestable evidence is that Alec Baldwin had what he knew to be a real gun in his hand, did not check or have anyone else check in front of him to make sure there was no live ammo in that gun, pointed that gun directly at Helena Hutchins, cocked the hammer, and pressed the trigger, firing the bullet that killed Helena Hutchins. That is a lack of due caution and circumspection when you're handling an inherently dangerous instrument. Ultimately, the mental state required for involuntary manslaughter is not that you intended to kill anybody. That would be murder. It's that, or it could be involuntary manslaughter if the intent was in the context of the heat of passion, in hot blood as opposed to cold blood. Involuntary manslaughter, you don't intend to kill anyone, but you're engaging in reckless conduct, conduct that you know creates an unjustified risk of death to another, and you ignore that risk and death results. The classic example, of course, is drunk driving. You get drunk in a bar, you get behind the wheel of your car to drive home. You're not intending to run anybody over and kill them. That's the last thing you want to do. You just want to get home. But you know, if you're drunk driving, you're creating a reckless, an unjustified risk of death to anybody else on the roadway. And if you do end up killing someone unintentionally on the way home because it was reckless, that is involuntary manslaughter. Here, the pointing of the gun at Helena Hutchins, cocking the hammer, pressing the trigger without ensuring it's not loaded, is that reckless conduct. It's knowingly engaging in conduct that creates a risk of death or serious bodily injury to another person, an unjustified risk, and doing it anyway, and death results. We also have the New Mexico jury instruction, which the defense complains about. The defense has their own version of the jury instruction they'd like to present. Specifically, and we'll come back to this in a moment, the defense wants the jury to be told that the only way to find Alec Baldwin guilty of involuntary manslaughter is if he actually knew that there was a bullet in the gun. We're going to see that the New Mexico involuntary manslaughter does not require actual knowledge. By the way, if you actually know the gun's loaded and you cock the hammer and press the trigger and shoot and kill someone, that would be murder. Then it's not speculative whether or not you're creating the risk. There's not merely a chance. If you're playing Russian roulette with somebody, you put one round in that gun, you spin the cylinder, you cock the hammer, you press the trigger, that's just murder. That's not involuntary manslaughter. And as we'll see, because what's happening in involuntary manslaughter is it's the risk creation.